What's up, everybody? Happy Monday. We're here to discuss a hearing that happened last week, what it means, what the state is going to have to turn over to the judge, what may get turned over to Brian Kohberger. But some of the more interesting thing were the subtle shots taken by the attorneys at each other in this case and the responses and the judge trying to calm everybody down. Now, this hearing was on Zoom. It's not a ton to watch or listen to specifically. I have listened to the entire hearing and I'm going to break it down for you and explain what they're actually arguing about because they're saying a lot of words, but it can get lost if you don't understand what it is each side is asking for and why the other side is objecting. It may seem like they might be trying to hide something. It may seem like they don't have it. It may seem like it doesn't exist. And it's one of those cases where one side is saying something is black and the other side is saying something is white. And both cannot be true. And there may be some accusations that one side is trying to mislead the court. So let's get into what was actually argued at this hearing. Hit that like button if you haven't already. The defense basically wants to set a deadline. That was the main goal for the scheduling hearing. It wasn't in person. It wasn't a big to-do. They just wanted to have the court say, Judge, we've been trying to get this stuff forever. This is one of the reasons we had to waive speedy trial. The trial just continues to get delayed and delayed and delayed until we get this information. Can we please force a deadline to where the state at least provides the information and the IGG stuff to you to review in camera, which doesn't mean there's going to be cameras on it. It just means basically in judges' chambers, the lawyers don't get to look at it. The sides they don't have to actually turn it over to the defense. But can we set a deadline to where they actually have to provide that stuff to you? Because Judge, now you're seeing what we've been dealing with the entire case. They won't even provide it to you, let alone to us. The state says, Judge, that's fine. You can look at what we have, but there's stuff missing. And we think it would be better if you reviewed everything at once. And the judge tends to agree. But the defense says, Judge, can't you just get what they have, see as much as possible, or give them a deadline, a drop dead date where they have to provide everything so you can have the full context that you want? And again, the judge said, well, yes, I'm inclined to set a deadline because I want everything in the full context to try to help understand something that's very complex and unusual and not something we do every day. In these cases, there are certain things judges can handle easily because it happens in every single case. This is not one of them. The state also mentions that the FBI is the delay because there's multiple SNP profiles by the private company that did it or the lab or whatever, and then the FBI. And the judge said, listen, here's what I'm going to do. Everything must be provided to me by December 1st. That's basically what the state was asking for, about a month, give them some more time. And so the judge said by December 1st, everything must be provided to me to review in camera so I can figure out what, if anything, the defense is going to get and what needs to be turned over to the defense. And here's how the state responded to basically something they asked for, meaning they asked for the judge to give them a month. They said, Judge, we will tell the FBI the date and everything that needs to be turned over, and we'll tell them that they must either turn over everything to you so that we can, or to us, the state, so we can give it to you, or have a good excuse. There are only certain entities or people you can say that about. If a court gives an order, most people have to just turn it over. A good excuse won't do for violating a court order. But when it's the FBI, if they don't turn something over, sometimes they can come in and tell the court, Judge, you don't have the authority to look at this. It's happened in our cases. I've had a trial where they've closed off the courtroom, kicked the defense attorneys out. And just an FBI agent talked to the court and explained to the court why we couldn't get in to certain cross-examination areas of where they place undercover wires or microphones or cameras or things like that in certain investigations because of national security. So things come up that are above, and that was in federal court. This is state court. So there are going to be things that come in above the judge's pay grade that the FBI can tell the court, we can't give you this or we won't give you this. Is that going to happen here? I don't think so. But the state's leaving the door open because, and the judge even says, well, I'll turn over what they give me. I'll do the best I can with what I have. Makes comments like that because they know the FBI might do things that only the FBI can do, which creates major problems in cases like this. And I think if they're not going to turn over how they got it or that it was legitimate or whatever it may be, they shouldn't be able to use it. Regardless, it seems to be agreement that they're going to provide everything they can to the judge to review to see what will go to Kohberger and his team. Now, the defense makes a little request. They say, Judge. The judge is like, anything else? The defense is like, yes, actually there is. Will you please make a privilege log of everything you see? And the state's like, well, the judge doesn't seem to have a problem with it, but the state's like, I'm not sure what they mean by a privilege log, Judge, because there's a lot of things that may be confidential. There could be third parties that are innocent, and we don't want their information to get out there. And the whole point of the in-camera review is there's a lot of information that should not even ever go to the defense. So in order to figure out what they're arguing about, we have to talk about what a privilege log is. A privilege log lists all documents or information provided. And if it's not provided to the defense, there has to be a reason why. The defense doesn't necessarily have to agree with that reason, but there has to be a legitimate legal reason why. And most of the time this comes up if you're suing a company or corporation and you ask for something that they say is privileged communications with, internal staff in preparation for litigation, or something that's intellectual property that they can't turn it over. But the reason they can't turn it over, they put in a privilege log. So what does that do? It does two things majorly, two major things here. First, it gives a list of everything that exists. And that's important to the defense, and we'll hear more argument on that later. But second, it also provides a reason why something on that list was not turned over. And what can lawyers do about reasons they don't agree with? Well, they can argue. And if they say this piece of paper exists and we don't think we should have to turn it over because it's privileged for X, Y, and Z, the defense can say, actually, the case law says we do get X, Y, and Z. So, Judge, we should get document 3 on this privilege log. And I don't think the state wants to provide all that information to the defense. So let's jump back now to a list of everything that exists. The state does not seem to want to do that. They want to give the judge information. If the judge says the state or the defense doesn't get it, then they don't even know that it exists. They can't make arguments about it because they just want to muddy the waters. The defense is trying to mislead the court, saying certain things exist that don't exist, Judge. That's some of the argument the state makes. The defense doesn't respond at this point, but it's clear that that's what the state is saying. Next, the defense argues, what does in camera mean? Which a lot of you have asked. But they don't mean whether or not there's going to be a camera there. The defense says they want to make sure that there's not going to be an FBI agent or somebody that works for the state that could direct the judge here or there while he's reviewing this information. The judge is a big boy. He's a lawyer. He's very competent. He's heard expert testimony. He's reviewed arguments. He's reviewed discovery requests. It is his job now to review this stuff in chambers and make a call. That's what judges do. And if one side disagrees with the call, they can appeal it. And the state says, well, Judge, we'll see kind of how it goes because we don't really know what we're going to turn over. And the judge says, listen, that's fair, but I'm not going to make a call until I see what I get. So he doesn't agree to a privilege log. He doesn't agree to make the state provide reasons why certain things aren't going to get turned over. And he doesn't even agree to not having an FBI agent or somebody else in chambers with him. But what he does say is, the only reason I'll have somebody in chambers with me is if A, I can't figure out how to open this stuff up. And you'd be surprised how often that happens with passwords and encryptions and things like that, where whoever turns it over to you, they make it so difficult that they have to be there when you open it up. He also says he may need an expert to help him dig through some of this stuff, and he may find one himself. And he also said there may be a situation where I'll invite the lawyers back while I review this stuff, and you guys can be there and see, and we can talk and discuss this stuff. Again, the judge, I really like the way the judge has handled this case. I really, really like it. And this hearing was no exception. He's playing judge. I shouldn't say playing. He's acting as a judge should. Saying, listen, I hear both sides. I'm not going to jump to a conclusion. It sounds like I should just agree with the defense, honestly. It sounds like you should say, you know what, defense, you're right. No FBI agent's going to be in there. That would be unfair. Sure, you get a privilege log. That's totally fair. yes, everything absolutely must be given to me by December 1st or heads are going to roll. No, that would be a waste of time. That would be just chest pounding for no reason. Empty threats. Because he knows if the FBI gives him a good excuse, there's probably nothing he can do. If he can't open the stuff that they give him, he might have to have an FBI agent in there. And if there's stuff that's actually, so confidential that they can't even let the defense know it exists, then they're not going to put it on a privilege log. This is a very sensitive case, a very public case. So the judge is going to wait until he has all the information. He doesn't want to do it piecemeal and maybe make a wrong call because he doesn't know what's coming later, especially when the defense is saying that's not everything. There's more, there's more, there's more. And there very well could be, which is kind of the last part of the argument. As they're talking about the privilege log, as they're asking for documentation, as they're asking for deadlines, the state says, listen, Judge, I believe the defense is being misleading. They're making statements that are not accurate. They're saying things exist that do not exist. They know they don't exist. They're just trying to mislead the court or muddy the waters. Again, I think this is like the third time in the argument that the state takes shots at Ms. Taylor and the defense. And once the state finishes that argument, the judge is ready to wrap the hearing. And Ms. Taylor's like, hold on a second, Judge. I need to respond now. It reminds me a little bit of the presidential debate. It's like, my name was invoked. They said something about me. Well, Ms. Taylor waited like 2 or 3 times when Thompson was taking shots. And she said, Judge, listen, I'm not going to stand for that. They keep saying we're misleading the court or providing inaccurate information or saying stuff exists, knowing that it doesn't exist. And that's absolutely false. A, we're never going to mislead this court intentionally. And B, the stuff we're asking for is from the documentation, policies, and procedures of theirs. And we had experts testify that this stuff should exist. And the judge made an interesting comment. He said, Mr. Thompson, I believe what the defense is saying, and Ms. Taylor, correct me if I'm wrong, but if it doesn't exist, then maybe, and I'm summarizing or, making just kind of an idea of what he said. This isn't an exact quote, but he said, the defense may want to make the argument that it should exist and doesn't. Very astute by the judge. Because right now the state's kind of saying, well, this stuff doesn't exist, or it did, and then it got destroyed in the normal course of business, or the FBI may have it, we just don't have it yet, which precludes the defense from saying it just doesn't exist, or it was destroyed improperly, or whatever arguments the defense can make that they are absolutely within their legal rights to make. And so it seems like the judge is going to say, if you're telling me this stuff doesn't exist, if the FBI is saying it doesn't exist, either by destruction, it was lost, or it was never created, or notes were never made, then fine. But the defense gets to know that. And they can make arguments. Now, of course, he's not saying you can make an argument. There may be an improper argument that was objected to, and the judge may not allow it. But at this point, the judge is saying, give me what you got by December 1st. I will review it. And if you can do it sooner, great. I'll say what needs to be turned over. We'll talk about what doesn't, whether it's going to get in a privilege log or not. I'll see who's going to be in chambers with me while I review. I'm going to leave that all open-ended until I actually see what I'm going with. Because the state also made it seem like a couple times, like when they're saying, well, we don't want to, overpromise and underdeliver. We don't want to make the court think it's going to be all this stuff. They almost make it seem like it's going to be a couple pieces of paper or some bare bones production that they're going to give based on this IGG information, which would be crazy with how much they're arguing and fighting over it if it's only like 100 pages. Because they're making it seem like it's going to be thousands of documents and information and notes and communication and ways they do things. But that's not that unusual either. Can't tell you how many cases where I've had defense counsel fight me, civil cases, not to turn over this document, just to tell me when the court orders that they have to turn it over, that it doesn't exist. Or that it's so voluminous and blah, blah, blah. And they're like, well, it's 10 pages, but it's a lot of information in those 10 pages. It's like, sure about that? So this stuff happens. I'm not making any accusations. I'm just giving you what reading between the lines of these arguments are. And I hope they turn it all over. And I hope the judge has an opportunity to look through and turns over to the defense what he should, doesn't turn over to the defense what he shouldn't. And we can have a fair and open process so that we have a fair trial and we're confident in whatever the result is. That's what I'm hoping for in this case. That is my one and only hope. All right, let me know your questions in the comments. I'm sure you have lots of them. I had lots of questions about what happened here, so I decided to do just a little breakdown and as short of a summary as I could without watching the entire hearing with them on Zoom and bad audio and things like that. But I appreciate you all joining me. As always, subscribe if you haven't already and hit that like button on the way out. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.